Thomas Johnson.
All right.
All right, sir, are you Thomas Johnson?
Yes, ma'am.
And Mr. Johnson, this is your initial appearance in cause number 24, DCCR 2265. You're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from September 8th of 2024.
Yes.
Since you've made bond, have you had an opportunity to try to hire a lawyer?
I have not.
Okay. What do you mean when you say you've had a long morning already?
Oh, my foot. I've had some metal fall out yesterday, so everywhere I'm going, I'm hobbling around, so it's just hard to get around on it right now.
Okay. Give me just a second to check something.
It makes for moving not so pleasant.
Did I test you this morning and have anything in your system?
No.
Let's double check that before.
You can tell right away. This judge isn't buying excuses today. Thomas Johnson walks in talking about a bad foot, a rough morning. Like that somehow changes the fact he's charged with evading police in a high-speed chase. And this is something people don't realize about court. The judge is always watching behavior, tone, body language, even hesitation.
The high-speed chase was crazy. I wonder whose it is. I mean, like 100 miles an hour down 105. They went from here to Hardin County and back and jumped out and ran in the woods and threw out drugs.
This is where everything flips. 100 miles an hour, county to county, running into the woods, drugs being thrown from the car. That's not a traffic stop. That's chaos. And once drugs enter the conversation, the court's patience evaporates. Community safety becomes the priority, not excuses.
But in addition to that, there's an allegation that drugs were thrown out of the vehicle during that chase, and that's why I ordered the drug test this morning. It's now 11 o'clock. I ordered this drug test prior to 9 o'clock. You have not been able to go or refusing to go to the restroom. Based on that, I am going to find that I'm going to assume that you are positive and that it is in the best interest of our community that I raise your bond, which is currently set at... Give me just a second to figure that out.
It was at 10,000.
10,000.
Yes, ma'am.
I'm going to raise your bond in your case to $30,000. A condition of that bond, if you make it, is that you wear a drug patch at all times. You will have 24 hours from the time you are released, if you make that bond, to have a drug patch put on. Your bondsman can let you know where to do that. You have to change it every 2 weeks. If it tests positive, you would be right back in custody, obviously. If it's not testable, then it's also going to be considered a positive drug screen. You can
Delaying a drug test in court is basically self-sabotage. The judge doesn't need a lab result at that point. Legally, she can assume the worst to protect the public. Raising the bond to $30,000 isn't punishment, it's control. It's the court saying, if you want freedom, you're going to earn it.
You're charged in cause number 25, DCCR 0114, with the second-degree felony offense of engaging in organized criminal activity from January 10th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Harris?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 7-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation, which could include me ordering you to some upfront treatment, or like ISF or something like that. And it looks like that's what the state's going to be requesting. Do you understand? And that decision's up to me when we come back for sentencing. All right, Mr. Jackson, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to recite your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing.
Then we switch to Camden Jackson, just 19 years old. This is the part that hits hard. He admits guilt. He's facing serious charges, but the system is still offering a path forward. Probation instead of prison. This is the fork in the road moment that defines someone's future.
So there's somebody, I think it was last week, that came in with a deal like this for a probation, and he didn't get it, and he's sitting back out at that jail. I do not have to accept this plea agreement. I'm going to read every single one of those jail incident reports. The disrespect that y'all are showing to the officers, I can assume what these are going to say, because y'all are all out there. It's the same group that's doing all the same thing, fighting, not following instructions, talking back, calling names. I'm going to read all of that. And let me tell you, if you have one between right now and your sentencing, I will not accept this plea agreement. I'm sick of it. The jail's sick of it. And I'm going to do whatever I can to make that place a better place for those people to go work who are out there just trying to do their job. Do you understand? One. We're not going to come in and say it was somebody else's fault. I only got one, or I got three, and that's not that bad. You can go out there and tell them, I want to get out and be on probation. I don't care what you guys want to do. I'm going to behave. If you have to sit on your bunk all day long and be quiet for the next 5 weeks, then that's what you do. Right? 5 weeks, rest of your life. What do you think? Show me you can do it, okay?
And then the judge snaps. Not because of one person, but because of a pattern. Jail staff disrespected, rules ignored, fights, mouth running. This isn't about power. This is about order. When judges talk like this, it's because they're done repeating themselves.
It will stop before you
Well,
this report back.
We'll see.
I'm threatening.
We'll see. I hope so. I hope they're having an easier time out of the jail.
That's what I'm thinking. I wonder what's up.
What's that?
That final warning is chilling. 5 weeks of discipline versus a lifetime of consequences. The judge makes it crystal clear. Probation is a privilege, not a right. One more mistake, and the door slams shut. Court isn't dramatic for entertainment. It's dramatic because real lives are on the line.